Welcome back to the channel, and in this video we'll look at the defenses to defamation. Please remember to also have a look at the other video that I've recorded on defamation, in which we look at the claim itself and what the claimant needs to prove in order to succeed. So in this video we'll look specifically at the defenses. Let's just begin by reminding ourselves what the claimant must establish to succeed in a defamation claim. Firstly, the claimant has to prove that there was a published statement. The claimant must be identified in the statement itself must be defamatory, and it must cause or be likely to cause serious harm to the claimant's reputation. Once those elements are proven, the burden then shifts to the defendant to establish one or more of the available defenses. So you see that in defamation cases, the burden is very much on the defendant, as opposed to other torts where most of the burden is usually borne by the claimant. This slide just gives you a visual cue of the statutory replacements of the common law defenses. So in 2013, the Defamation Act 2013 was enacted, and that to a large extent both codified but also significantly changed the common law on defamation. With regards to the common law defenses, for some of these, the defense changed fundamentally. For instance, the common law Reynolds defense, which was the responsible journalism defense, this defense was abolished and replaced with the defense of publication in the public interest. For others, the name may have changed, but the substance is the same. So, the common law defense of justification is now simply called the defense of truth, but it is essentially the same defense. The same goes for the defense of privilege. Fair comment and honest opinion are very similar with the statutory replacement, very similar to the statutory replacement honest opinion, but honest opinion now covers a wider scope than the common law defense of fair comment. We'll look at the main defenses in turn. The first and most straightforward defense is truth. Under Section 2 of the Defamation Act 2013, it is a defense to show that the imputation conveyed by the statement complained of is substantially true. In other words, the sting of the allegation, that is, the core defamatory meaning, must be true as a matter of fact. This defense replaced the old common law defense of justification. The defendant does not have to prove every single detail of the statement is true. It is enough if the substance or the main charge is substantially accurate. The courts focus on whether the defamatory meaning of the statement is true in substance, even if some minor details are wrong. For example, if a newspaper accuses someone of committing fraud involving £1 million, but the evidence shows they defrauded £900,000, the defense of truth would likely still succeed because the essence of the allegation is accurate. Let's look at a recent high-profile case that illustrates the defense of truth. Vardy versus Rooney 2022 case, otherwise known as the Wagatha Christie case, was a truly spectacular defamation case which gave rise to numerous newspaper articles, podcasts, TV dramas, and documentaries, and even a West End stage show. It involved two so-called wags, the term for wives and girlfriends of famous former England footballers Jamie Vardy and Wayne Rooney, who subsequently became celebrities in their own right and friends, until they had a spectacular and public fallout. Colleen Rooney disclosed very dramatically in an Instagram post that her former friend, Rebecca Vardy, had leaked private stories about Rooney and her family to the press in return for payment. Vardy denied this claim and sued Rooney in defamation. However, Justice Steyn found the Instagram statement by Rooney to be substantially true, and therefore Rooney's defense of truth defeated Vardy's libel claim. Rooney did not seek any compensation, but Rebecca Vardy was ordered to pay up to £1.5 million of Rooney's legal fees. Now, this is usual practice because, as you'll remember, in civil cases, the rule is costs follow the event. which means that the loser in the claim has to pay the legal costs of the winner. Don't forget that Vardy would have had to pay her own lawyers as well. So if you add all of that up, it means that she probably faced legal costs of around £3 million. With hindsight, it looks as if Vardy was really foolish or foolhardy to sue, and even more so to reject the allegedly repeated offers that Rooney made to settle the matter out of court. Jim Waterson in the Guardian newspaper came to the conclusion that, and I quote, "Not only did Vardy voluntarily bring a libel case that destroyed her own reputation, she will also have paid millions of pounds for the privilege of being publicly humiliated." End quote. However, on the other hand, another commentator, David Allen Green, notes, and I quote, "Judgments can seem more one-sided than the reality of the case. If Vardy's case was inherently weak, then it would not require a 75-page judgment with 290 paragraphs. In the end, the judge went with Rooney's case on each disputed point. But had some of those points gone differently, Rooney may have failed in her defence. And it was for Rooney to prove her defence, and not for Vardy to disprove it. Despite the PR disaster of the hearing for Vardy, it was not obvious that Vardy would lose until the judgment was handed down." End quotes. I'll post references to both of these commentators' articles and also to a very highly regarded textbook, which you might want to check out in the description below. What this case illustrates then, and it illustrates it really well, is that we had the four elements here for defamation. First, there was a publication. Second, the statement that was published was defamatory. Thirdly, it identified the claimant, Rebecca Vardy. And finally, her reputation was seriously harmed. So all of the requirements for defamation were there. But on the other hand, we also had the court agreeing with the very strongest defense that can be raised in a defamation claim, namely, that the statement complained of was the truth. The second major defense after truth is that of honest opinion, found in Section 3 of the 2013 Act. This replaces the old common law defense of fair comment. The defense of honest opinion recognizes that people are entitled to express opinions, provided that they are honestly held. The aim is to protect editorial comments, reviews, and opinions on matters of public concern. Now, to rely on this defense, the defendant must show three things. Firstly, the statement complained of was an opinion, not a statement of fact. Secondly, the statement indicated, at least in general terms, the basis of the opinion, that is, the facts on which the opinion was based. And finally, an honest person could have held that opinion on the basis of those facts. It does not matter whether the opinion is reasonable or whether others would agree with it. What matters is whether it is genuinely an opinion that could be honestly held. Importantly, this defense doesn't require the opinion to be on a matter of public interest, unlike the next defense that we'll look at. The next defense is absolute privilege. Under Section 7 of the Defamation Act 2013, certain occasions are protected absolutely, meaning that even if the statement is false and malicious, no action for defamation can succeed. Absolute privilege covers statements made in Parliament by members of Parliament or Lords or published in official parliamentary reports, statements made in judicial proceedings by judges, lawyers, witnesses or parties, statements made by one officer of the state to another in the course of duty, and even statements made between spouses. This defense exists because public policy demands that certain communications must be absolutely uninhibited. For example, witnesses must be able to testify freely without fear of being sued for defamation. Similarly, MPs must be able to speak openly in Parliament. A famous modern example is when Sir Philip Green, well-known billionaire, here you can see him with Kate Moss. He made his millions through fashion empires such as Topman and Topshop. So, Sir Philip Green was named in Parliament as the businessman involved in the British Me Too scandal. That statement could be made freely in Parliament under absolute privilege, even though newspapers could not before then, safely repeated because there was an injunction that had been taken out by Sir Green to keep his identity a secret. So let me just play you. Right, so that was an example of absolute privilege being used in Parliament. So remember, absolute privilege is related to the place where the statement is made, in Parliament, in court, in a judicial proceeding. The next defense is qualified privilege, which protects statements made on occasions where there is a duty or an interest to communicate information and a corresponding interest in receiving it. So where absolute privilege depends on where the statement is made, qualified privilege depends on under which circumstances the statement is made. The leading case on this is Adam and Ward, 1917 appeal court case. In that case, the House of Lords defined a privileged occasion as one where the maker of the statement has a legal, social, or moral duty to make it to the person who receives it, and that person has a corresponding interest in receiving it. Crucially, there must be reciprocity of duty and interest. A classic example would be an employment reference. An employer has a moral and social duty to give a fair reference and to speak as openly and truthfully as possible. And the prospective employer has an interest in receiving such a statement. This means the reference will generally be protected by qualified privilege, unless it is made maliciously. Qualified privilege can be defeated as a defense if the claimant shows that there was malice on the part of the defendant. That is, that the defendant was motivated by spite or ill will or some improper purpose rather than a general sense of duty. Under the Defamation Act 2013, certain forms of qualified privilege are set out specifically in the statute. Section 6, for example, protects peer-reviewed statements in scientific and academic journals. Section 7 extends privilege to other categories, such as reports of legislative and judicial proceedings, or public meetings and press conferences. However, just like the common law version, statutory qualified privilege does not apply if the statement is made with malice or if the defendant did not honestly believe that the statement was true. The next major defense is publication on a matter of public interest. This is under Section 4 of the Defamation Act 2013. This defense replaces and abolishes the old common law Reynolds defense, which was also known as the so-called responsible journalism defense. To rely on the defense of publication on a matter of public interest, the defendant must show two things. Firstly, the statement complained of was or formed part of a statement on a matter of public interest. And secondly, the defendant reasonably believed that publishing the statement was in the public interest. This defense applies not only to journalists, but also to anyone publishing material on issues of public importance, including NGOs, non-governmental organizations, and even social media users, depending on the circumstances. Let's therefore look briefly at three key cases in which the defense was raised. First off, Economou versus De Freitas, which was a 2018 appeal court case. This case clarified that the Section 4 defense applies to ordinary individuals as well as journalists. The Court of Appeal held that a man who made statements defending his late daughter's reputation after she was accused of making a false allegation could rely on the defense. The key point was that he had acted responsibly and believed publication was in the public interest. In Serafin versus Malkiewicz, the Supreme Court reaffirmed that the court must assess the defendant's belief in light of all of the circumstances. The focus is on whether the belief was reasonable, not whether the statement turned out to be true. And finally, in Banks versus Cadwallader, these are the people I've got on the slide here, Mr. Aaron Banks and Ms. Caroline Cadwallader. I hope I pronounced that correctly. In this recent case, also a case that went to the Court of Appeal, the journalist Carol Cadwallader initially succeeded with the public interest defense for statements about the millionaire Aaron Banks and alleged links that he had to Russia. However, The defense failed once circumstances changed and it was clear that there were no such links to Russia, and she no longer could believe that continued publication was in the public interest. The facts of the case and the outcomes are quite complex, so do keep a good timeline next to you when you read this case. But the key point here is that the case illustrates that the reasonableness of belief can evolve over time. Overall, the defense recognizes the importance of protecting freedom of expression on matters of public concern, provided that the publisher acts responsibly and in good faith. Sections 5 and 10 of the Defamation Act 2013 protect those who are not the author, editor, or publisher of the defamatory material. Section 10 provides that a person who is not the author, editor, or publisher cannot be sued unless it is not reasonably practicable to bring the action against the actual author, editor, or publisher. This provision is designed to prevent peripheral or technical defendants, such as the distributors, from being unfairly targeted. Section 5 provides a specific defense for operators of websites. It recognizes that online platforms often host content that are posted by others. If they can show they did not post the material and took reasonable steps to remove it when notified, they can rely on the defense. The overall aim is to balance accountability with practicality in the digital age, protecting those without editorial control over content. Two further defenses should be mentioned briefly. Firstly, consent. If the claimant consented to the publication of the defamatory material, they cannot later claim damages. And, as you know, consent is a complete defense. Secondly, an offer of amends. Under Section 2 of the Defamation Act 1996, a defendant who has published a defamatory statement can make a formal offer to make amends, typically by publishing a correction and apology and paying compensation. If the claimant accepts the offer, the claim is resolved. If they refuse, the defendant can rely on the offer as a partial defense to limit damages at the end of the trial. So far, we have focused on the various defenses available to defendants in defamation actions. In our next and final slide, we briefly look at the remedies available to claimants when a defamation claim succeeds. There are two main remedies in defamation: injunctions and damages. Injunctions are used to restrain publication or further publication of defamatory material. Interim injunctions are rare because of the strong protection of free speech under Article 10 of the European Convention on Human Rights. Courts will only grant them where it is clear that the statement is false and indefensible. The primary remedy is damages, which aim to compensate the claimant for harm to reputation, not to punish the defendant. The award would reflect several factors, such as the seriousness of the allegation, the extent of the publication, the nature of the defendant's conduct, both in making and in defending the statement, and aggravated damages may be awarded where the defendant's behavior increased the injury, for example, through refusing to apologize or repeating the allegation. In extreme cases, exemplary damages may be available where the defendant's conduct was oppressive, arbitrary, or calculated for profit. To summarize then, defamation law strikes a delicate balance between protecting reputation and safeguarding freedom of expression. The modern framework under the Defamation Act 2013 provides clear statutory defenses: truth, honest opinion, public interest, and others, alongside long-standing common law principles like privilege, which have been retained. Remedies focus on repairing reputational harm rather than punishing the defendant. Thank you for watching, and remember to also have a look at the first part of the discussion of defamation. I'll put a link in the description below. And if you find the content useful, please do remember to like and subscribe. And as I'll be posting many more lectures on legal issues pertaining to tort. See you in the next one.